Welcome to Term Talk, the video podcast from the Federal Judicial Center that discusses the Supreme Court term opinions with the most impact on lower courts. I'm Francesca Williams, education attorney for executive education at the Federal Judicial Center. In about the next 10 minutes, we're going to discuss two opinions that redefine how important federal criminal laws can be prosecuted. Joining me to do that are Laurie Levenson, professor, and David W. Burcham, chair in ethical advocacy at Loyola Law School, and Evan Lee, emeritus professor at University of California Law, San Francisco. Thank you both for joining us today. Fischer v. United States was the much anticipated opinion that impacted how some defendants were charged after the January 6th attack on the Capitol. Evan, this case turned on the interpretation of what constitutes an obstruction of official proceedings under 18 U.S. Section 1512C. What does that statute say, and what language was at issue?
1512 is part of the Sarbanes-Oxley Act of 2002, which was enacted in the wake of the Enron accounting scandal, which, of course, involved the mass destruction of documents. And what subsection C says is whoever corruptly, one, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so, with the intent to impair the object's integrity or availability for use in an official proceeding, or two, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. So the issue here is C2. When I say otherwise, that's a residual clause. And the question is the residual clause a catch-all for everything that falls through C1, or is it sort of a catch-sum that's limited in its scope by the reference points in C1?
Evan, so what was Fischer accused of doing here?
Well, Fischer took part in the events of January 6th when Trump supporters battled police. They stormed the Capitol, disrupted the certification of the 2020 election. And Fischer was charged with assaulting an officer, unlawful entry into and remaining in a restricted building, and disorderly and disruptive conduct while in the Capitol. Now, that third count alleged violations of the statute that we've been talking about, 18 U.S.C. 1512 C2. Fischer argued that that count only applies to attempts to impair the availability or integrity of evidence. He was convicted under C2, despite his argument. And there were about 300 other defendants who were similarly charged. None of them were charged exclusively with 1512 C2, but those 300 were charged with one of those counts. The Supreme Court held that subsection C2 is, as I referred to before, more of a catch-sum than a catch-all, that the scope of C2 is limited by C1, and therefore that nobody should be convicted under C2 who hasn't been proved to have impaired the integrity or availability of evidence. It was a bit of an unusual split in the voting here. You had a 6-justice majority with Chief Justice Roberts, Justices Thomas Alito, Gorsuch, Kavanaugh, and Justice Jackson. And then in dissent, it was Justice Barrett, joined by Justices Sotomayor and Kagan.
Thank you. Laurie, can you take us through the court's reasoning, please?
Yes, Chief Justice Roberts, who wrote the opinion, used two canons of interpretation. Under the first canon, it says that the words are given more precise context by their neighboring words. And then he used the canon that says general or collective terms at the end of the list, typically controlled by reference to specific classes preceding it. Because the statute, as Evan described, was created to criminalize the document and evidence destruction from the Enron scandal, the Chief Justice said, look, we have to keep that catch-all provision within the area that it was designed. Otherwise, if it just is a catch-all for all residual obstruction, it would basically swallow the whole rule of C1. That was an approach, Francesca, that they had used with the ACCA, because I think they used that approach here, or the Chief Justice noted, otherwise you might have peaceful protesters or activists who would end up getting a 20-year sentence. As mentioned, Justice Jackson actually concurred in this, but she stressed that she would look at the legislative purpose of the analysis rather than the textualist one. And she also used very harsh words in her concurrence, more than the majority, referring to that this was indisputably abhorrent, that was inflicting deep wounds on the nation, but she agreed with the statutory approach.
Interesting. Evan, in what ways did the dissent disagree?
Justice Barrett wrote a spirited dissent and argued that C2 prohibits obstructing or influencing or impeding an official proceeding by means different from those specified in C1. She said that each crime represents one means through which to obstruct or influence or impede an official proceeding. And she argued that Fischer's conduct delayed and blocked a congressional proceeding by means other than document destruction and therefore falls within C2. She said that Chief Justice Roberts' interpretive canons were inapposite because 1 and 2 are separate provisions. And she said the court should follow what Congress wrote, even if they disagree with how they wrote it.
Well, Evan, the big question is, what does this opinion mean for the lower courts?
Well, as Laurie mentioned, I think it does give us an idea of how to interpret such language and constructions in similarly structured criminal statutes. Laurie mentioned the Armed Career Criminal Act. I think that's a good example.
Laurie, do you have anything to add?
Yes, I do. I think we should all note that even under this decision, the Department of Justice can still use the statute in relation to perhaps the delivery of the electoral votes. And if they brought an action that said that the defendants impeded their delivery or tried to destroy those votes, those would still be covered by this statute.
Let's turn to Snyder v. United States. It's another opinion that strictly construes a statute that has been much used and unquestioned for years. Evan, can you get us started on this case, please?
Sure. You're referring to 18 U.S.C. section 666 and specifically A1B, which I'm going to read now. It says, anyone who corruptly solicits or demands for the benefit of any person or accepts or agrees to accept anything of value from any persons intending to be influenced or rewarded in connection with any business, transaction, or series of transactions of such organization, government, or agency involving anything of value of $5,000 or more is guilty under this provision. Now, the statute that I just read was amended. That's the amended version that I just read. And there's a split in the circuits as to whether this amended version still includes what we refer to as illegal gratuities, the crime of accepting illegal gratuities, as well as the crime, the more traditional crime of bribery. And this case resolves that split against the continued coverage of illegal gratuities. So let me just quickly run through the facts of this case. James Snyder was the mayor of a small town in Indiana. The city awarded a $1.1 million contract to Great Lakes Peterbilt, which is a local truck company. The following year, that company gave Snyder $13,000. He claimed the money was for consulting. He wasn't charged by local prosecutors, but federal prosecutors did charge him under this section. and he was convicted by a federal jury for accepting an illegal gratuity. The Seventh Circuit on appeal affirmed. He argued this statute as amended doesn't cover gratuities anymore. The Seventh Circuit said, we disagree. We're going to affirm the conviction. But in this case, the Supreme Court 6-3 held that 18 U.S.C. 666 as amended no longer applies to illegal gratuities.
Well, Laurie, can you take us through the court's analysis on this?
Happy to do so. Justice Kavanaugh wrote for the majority. He was joined by Chief Justice Roberts, Justice Thomas, Alito, Gorsuch, and Barrett. And they went through a series of steps to analyze the statute to see if it would cover such a situation. They started with the text of the statute. And they said that even though the statute originally was modeled after statutes that criminalize bribes and gratuities, it ended up not containing the same language that criminalizes gratuities. The justice then went through the statutory history, talking about in 1980, they had Section 666 that extended the prohibitions that applied to federal officials, which applies gratuities as well, to state and local officials. But then in 1986, it was amended out of concern that it might actually capture acceptable commercial and business practices. The next factor the court looked was statutory structure. And typically you wouldn't see sort of separate types of elements and crimes in the same provision. Statutory punishment. They talked about that this would criminalize bribery and gratuities the same, unlike, in fact, for federal officials who are subject to prosecution for gratuities, but not at the same level. The court looked at federalism, and it said that, as Evan explained, it would impose penalties for conducts that states and localities might choose not to criminalize. And finally, the court looked at fair notice and said it would be difficult, frankly, for officials to determine what constituted an illegal gratuity. So that was what the majority said. There was a concurrence by Justice Gorsuch, who summed it up this way. He said this is really just about applying the rule of lenity to what is an ambiguous criminal statute.
Thank you, Laurie. Evan, it's not a complete picture without the dissent. Can you share what the dissent's reasoning was?
Yes, Justice Jackson, joined by Justices Sotomayor and Kagan, said, you missed the mark here. This is not about federalism because there's a clear federal interest involved here, and that is protecting the integrity of federal funds. You can't expect local prosecutors, she said, to protect the integrity of federal funds.
So what are the takeaways here for our audience?
Well, one thing I think it's important to remember is just going back to kind of black letter criminal law and saying this case really illustrates the difference between bribes on the one hand and illegal gratuities on the other hand is the presence or absence of an agreement for a quid pro quo. If you have such an agreement, it's a bribe. If you don't, then that payment is either an illegal gratuity or it's no crime at all. And the court here, as Laurie said, is leaving it up to state and local governments to regulate gratuities to state and local officials as they see fit.
Well, Laurie, I leave you with the final word on this.
I think the final word is that the court has left it to the states and localities to really prosecute whether these are gratuities. And so the federal government will have less of an opportunity to protect their funds in this situation unless it clearly involves a bribery situation.
Well, thank you so much for sharing your expertise and joining us today.